My name is Keyvan Rastegar. I'm the co-founder of RPCK Rastegar Panchal, and our project is the FlexCo. To understand just how big this reform was to us in Austria, we'd have to look back to 1906, which is when we created the last corporate entity, the Austrian GmbH. Back in the day, it was the third kind of private limited company in the world after Germany and Portugal. Super innovative back then. And then over 100 years passed, and there was very little reform. And so the status quo prior to this reform in Austria was, in fact, that we were missing a whole bunch of needed updates to our legal system. We had very little freedom of contract, starting with not being able to create different share classes, in fact, not even having shares. Instead of having shares, we had essentially a part of the share capital. We had very high minimum capital requirements, very high minimum denominations of share capital, super bureaucratic transfers of shares, setting up a company, highly bureaucratic, very difficult to allocate shares to investors. We didn't have authorized share capital, no convertible capital like convertible notes or safes, no treasury shares, no redemptions or recalls of shares. So we set out to change that. And starting with a couple of decades of various industry groups publishing white papers and putting together lists of things that need to be done, this specific project was kicked off in 2020 when the Ministry of Justice created an expert group, appointed me alongside two other attorneys and some 30 other experts to work out an overhaul of the corporate law system and bring it closer to international standards. After a year of work in the reform group, it became pretty clear that there were a number of things that from an Austrian perspective, were considered super innovative and appropriate for growth companies and ventures. But a huge sticking point was that a very small minority of legal stakeholders, particularly notary publics, court clerks, were strongly opposed to any kind of reform. And that really surprised a number of the participants because we were essentially working on mechanical reforms and came to learn that, in fact, a number of the reform projects across Austria, but also the European Union and other jurisdictions, turns out, didn't manage to overcome these obstacles. And small special interest groups had successfully prevented modernization because they stood to benefit to the tune of billions from the fees generated from this kind of red tape. So we learned that basic innovation and moving these things forward was also a story about coming together, coalescing across party lines to cut the red tape. 2 more years of really intense political negotiations ensued, involving essentially the system. So all ministries, Ministry of Labor and Commerce, Ministry of Justice, our Ministry of Treasury or Minister of Finance, as we call it, up until the chancelleries, members of parliament, members of cabinets of the ministries and of the sections within them. We brought together legal academics, so law school professors, experts from practice, folks from think tanks, political organizations, etc., to coalesce around the substance of the matter across ideologies and party lines, and simply do benchmarking and show how many other jurisdictions had moved forward with these kinds of innovations, and trying to create the environment for our social entrepreneurs, for our impact investors, but essentially for all businesses across the spectrum, across industries, to benefit from these new innovative opportunities to grow companies. Essentially, the 3 reform goals were to reduce bureaucracy, specifically notarial bureaucracy, but also bureaucracy at the company's house, to increase freedom of contract, which not only is an obvious international standard in drafting, that you can actually draft what you would, by and large, what you would like to put into your contracts, but is in fact also a human right, derives from the freedom of property, the right to own property and thus also contractual rights, is in Austria even a very clearly adjudicated constitutional right. So we wanted to increase freedom of contract, including being able to create share classes. In fact, even have shares, which we didn't up until that point, rather only a stake in the share capital. That we could do circular resolutions without having 100% of the shareholders' consent and just speeding up processes within companies, reducing minimum capital requirements, which barred low-income founders and discouraged, in particular, it turns out, immigrant and female founders from setting up companies. And as a key part of the project, creating a structure, both from a corporate but also from a tax law perspective, where employees could be given shares to participate in the upside of the company. And we argued that that's a great thing to align interests and create loyalty and just be working on something together. And to our surprise, Austria is the kind of country where whether you like it or not, as an employee, you're a member of the Chamber of Labor. And as an entrepreneur, whether you like it or not, you're a member of the Chamber of Commerce. And in the negotiations, it became clear to us that the Chamber of Labor here took the position that it was detrimental to employees to receive shares because they'd be too risky. And their reasoning was that employees would become confused about their belonging to the Chamber of Labor, or rather Commerce, and that they might even cross party lines. And that kind of thinking we found obviously terrifying. And we worked together, the vast majority of folks working on this worked together to show that these kinds of things can be done in a way that protects employee rights and is entirely beneficial to them. And we got there. So we introduced some more freedom of contract. We created chairs, we created chair classes, we created virtual meetings, hybrid meetings, moderated meetings, especially since part of the reform was negotiated during the pandemic. So it was negotiated on Zoom or on Teams. We simplified shareholder resolutions. We reduced the share capital from 35 to 10. We reduced the minimum share denomination. Me personally, I'd advocated for 0 minimum capital and the ability to choose between par and no par shares. We strongly advocated to remove the notarial deed requirements across the spectrum because, to transfer shares, to allocate shares, but in fact, to even amend the constitutional documents of the company. In fact, to file anything with the company's house, you had to pay fees to a notary public who would then, in many cases, read the document that you drafted back to you. So we managed to reduce 2 requirements for share transfers and allocations as a good first step in the right direction. We introduced treasury shares, share recalls, authorized capital, convertible capital, and to top it off, the statute was written in the all-female generic form. In Germany, you have the female, male, and neutral form. Most language is written just historically in the generic male form, but to signal to female founders and investors, this was the first federal statute ever written in the generic female form. And so this project symbolizes a bunch of things. It's hopefully innovative in the sense that in a jurisdiction where these things were like water in the desert, we managed to bring them, introduce them. It's a beautiful story of people working together across party lines, across governmental institutions, between government and private practice. And it's a really important story of overcoming special interests that we think can serve as a blueprint, not only for neighboring countries, in particular Germany, but really towards the unified European projects of a common European entity that makes it super easy to do business across the European Union and then globally. And so we really look forward to your support and believe this is a very important step in the direction of ease of doing business and creating rules that benefit all these stakeholders, so entrepreneurs, investors, employees, and the economy at large, even if it means that we as lawyers in certain cases stand to earn a little bit less. Thank you so much for your attention.